Hi, my name's Tim Murphy and I practice landlord-tenant law in Portland, Oregon. One of the questions people ask me all the time is, how do I issue a termination notice or a rent increase notice or the notice that's necessary in order for me to enter into my rental property? Well, a rent increase notice or a termination notice has to be in writing. This means a piece of paper and not an email or a text message. This written notice can be delivered by first-class mail or by personal delivery. If the rental agreement allows it, it can also be served by posting to the property and mailing to the property at the same time. Whenever mailing, please ensure that you use first-class mail and not certified mail. Certified mail is almost never allowed under the Landlord-Tenant Act. For a rent increase notice, the notice must state the amount of the rent increase, the final new rent that's going to be due, and when that new rent is due. A rent increase notice must be issued at least 90 days before the increase takes effect, and it can only be issued after the first year of a month-to-month tenancy. And a notice to enter a property is different. It's called actual notice. Actual notice can be delivered by a phone call to your tenant, a voicemail, a fax, a first-class letter. Oftentimes it can be done by email or text message. After actual notice is provided to the tenant, a landlord must provide at least 24 hours actual notice to a tenant before the landlord can enter into the tenant's rental property. The tenant is allowed to deny entry, in which case the landlord must ask again or perhaps seeks the court assistance if the tenant continues to deny entry. Actual notice can be given in a lot of different ways, and it's smart for a landlord to try to use a method they can confirm the tenant actually received the notice. For more questions and answers, please see the Oregon State Bar's website. Thank you.